K.M. Munshi on 26th of March 1947 puts forth before the Subcommittee of Fundamental Rights Article 6. I request my lords to make a note of Article Roman 6, because it is this Article Roman 6 that becomes Article 1314 at some point, Article 1920 at some point, Article 2021 some point, and then becomes 2526. That is the journey of this entire thing. Now kindly take a look at the language here. This will show that 25.2 is only subject to 25.1 once more. Rather, it applies only to 25.1. All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health. The right to profess and practice religion shall not include economic, financial, or political activities associated with religious worship. My lord sees that. Then, so what was given as a proviso is then fused into a composite provision. Then my lords may come to the next page. At para number 9 on page number 6 is the revised version of Article 26 introduced as part of Sri B.N. Rao's draft. Please see what it says. Every religious denomination shall have the right to manage its own affairs in matters of religion and to own, acquire, and administer property, immovable and movable, and to establish and maintain institutions for religious or charitable purposes consistently with the rights guaranteed in this Constitution. This becomes later in accordance with law under 26D. Now, my lords would see what is missing here is, my lords would see that public order and morality is completely missing here in this particular draft. That gets introduced later. So I'll show that. Now, my lords may come to para number 10 at page number 6. This is the combined draft of Article 6, which is the future Articles 25 and 26, as adopted on the 26th of March 1947. My lords would see that clause 1 of Article 6 is proto-Article 25, or the predecessor to Article 25, rather 25.1. Then my lords would see that the explanation with respect to Kirpans has already come. And please see, 25.2 was then inserted as an explanation to clause 1. Right. Therefore, it was always meant to be limited in its application. I'm just reiterating that point over and over again, that it never severs the umbilical cord that connects 25 and 25.2 throughout its entire history. It becomes an explanation, it becomes a proviso, then it becomes 25.2. That's the only difference. Then kindly see this. This is the new clause that Sri B.N. Rao recommends at the bottom of Article 26. My lords could see, kindly see the bottom of page number 6. Every religious denomination shall have the right to manage its own affairs in matters of religion, so on and so forth. My lords has already seen that. Now I request my lords to come to the next page.
Where it says consistently with the rights guaranteed in this Constitution.
And then my lords would, my lady would see how that language gradually changes.
That is because it becomes diluted.
I'm so grateful. It becomes diluted, and not just that. Wherever it refers to clause 6, that is clause 1 of Article 6, which is 25.1, initially it kept saying subject to the rights in this chapter. That chapter becomes part later because everything is reworded. So chapter becomes part. And I'll show all of those changes as well. Kindly come to the next page. Para number 11 at page number 7. My lord sees that?
Yes.
My lord, Justice Mahadevan has it?
Yes.
Please.
One more.
I'm so grateful. On 27th of March 1947, the following portions were added to clause 6. Now begins the Irish influence. So 44 to degree 1 and 44 to degree 5. Degree 1 speaks of 25.1, degree 5 is 26. So denominational rights come from Article 44, Clause 2, degree 5 of the Irish Constitution as it existed then. Article 44, subclause 2 and degree 1 was the equivalent of 25.1. Now kindly take a look at this. My lady may come to, in fact, my lady can, my lords can perhaps ignore para 11. Kindly come to para 12 on the next page. On 29th of March 1947, this is proposed. The provision relating to freedom of conscience and the right freely to profess and practice religion was amended so as to include at the end of the words and with other rights guaranteed by this Constitution, which becomes a reference to subject to part 3. Then kindly see para 13. On 30th of March 1947, the following explanation was sought to be added. To clause relating to freedom of conscience, add the following explanation. This is explanation 3. No person shall refuse the performance of civil obligations or duties on the ground. Gradually, this explanation is done away with at a later point of time. Specifically saying, how do we deal with this particular situation? Because what was the facts? Can I just take 30 seconds to explain what happened in Jehovah's Witness case in my own words? With my Lord's permission. May I, minutes? So, in the Jehovah's Witness case, the witnesses, or rather the practitioners of that particular denomination, also took an anti-national oath, specifically saying that they will not swear allegiance to the empire of Satan. That was a specific position. Then they also had properties where they would undertake their own discussions to, let's say, give effect to their belief. The government took over that entire building. The court finally said, you can kill the effect, but you can't kill the practice of the belief, which means you can take the property, but you don't get to say that they can't believe in this. That was the position ultimately that emerged in it. Kindly take a look at para number 16 at page number 10. Now, there are 3 ladies who have played a formative role in the formation of fundamental rights across the board. Hansa Mehta, Rajkumari Amrit Kaur, and of course, you have Mr. M.R. Masani. Can I request my lords to kindly take a look at the top of page number 10 just for a moment? Please see this. Durga Bhai Deshmukh. I'll come to that. The right to profess, I'm so sorry, sir. Thank you. The right to profess and practice religion shall not preclude the legislature from enacting laws for the social betterment of people. This is the prototype of 25(2)(b), which again shows, so we can't argue that 25(2)(a) applies to 25(1), but 25(2)(b) applies to everything. That may be a bit of a problem to argue, because if nothing in this article is the preamble to 25(2), that means both portions of 25(2)(a) and (b) apply or don't apply only to 25(1), not to 26. That is the history of this particular provision.